Hey guys, welcome back to my channel Practical Learning Assets. So in our last video, we discussed what are fundamental rights and also we discussed two fundamental rights. So in today's video, we will cover the chapter further. So let's start with the video. First comes the right against exploitation. In our country, there are people who are underprivileged and deprived and are subjected to exploitation by their fellow human beings. One such form of exploitation in our country has been begar or forced labor without payment. Another closely related form of exploitation is buying and selling of human beings and using them as slaves. Both of these are prohibited under the Constitution. Forced labor was imposed by landlords, moneylenders and other wealthy persons in the past. Some form of bonded labor still continues in the country, especially in brick kiln work, and it has now been declared as a crime and it is punishable. Our Constitution also forbids employment of children below 14 years of age in dangerous jobs like factories and mines. Now, with child labor being made illegal and right to education being fundamental right for children, this right against exploitation has become more meaningful. Then the next right is right to freedom of religion. According to our Constitution, everyone enjoys the right to follow the religion of his or her choice. This freedom is considered as a hallmark of democracy. This means that every person in our country is free to follow and profess any religion. He or she is free to change his or her religion until and unless he or she is changing it with his or her consent and without any pressure. Now, under right to freedom of religion comes freedom of faith and worship. Now, freedom of religion also includes the freedom of conscience. This means that a person may choose any religion or may choose not to follow any religion. Freedom of religion includes the freedom to profess, follow and propagate any religion. Freedom of religion is subject to certain limitations and the government can impose restrictions on the practice of freedom of religion in order to protect public order. The freedom of religion is not an unlimited right and the government can interfere in religious matters for rooting out certain social evils. For example, the sati pratha, bigamy or human sacrifice. The limitations on the right to freedom of religion always produce tensions between followers of various religions and the government. But the Constitution has guaranteed the right to propagate one's religion, and this includes persuading people to convert from one religion to another. The Constitution does not allow forcible conversions. Then comes equality of all religions. India does not have any official religion and we do not have to belong to any particular religion in order to be a prime minister or president or a judge or any other public official. Under the right to equality, there is a guarantee that the government will not discriminate on the basis of religion in giving employment. The institutions run by the state will not preach any religion or give religious education, nor will they favor persons of any religion. The objective of these provisions is to sustain and nurture the principle of secularism. Then comes cultural and educational rights. Our Constitution believes that diversity is our strength. Therefore, one of the fundamental rights in our Constitution is the right of the minorities to maintain their culture. This minority status is not dependent only upon religion. Linguistic and cultural minorities are also included in this provision. Minorities are groups that have common languages or religion and in a particular part of the country or in the country as a whole. They are outnumbered by some other social sections. All minorities, religious or linguistic, can set up their own educational institutions and the government will not, while granting aid to the educational institutions, discriminate against any educational institution on the basis that it is under the management of minority community. Then comes the right to constitutional remedies. This right gives a citizen the right to approach a high court or the Supreme Court to get any fundamental rights restored in the case of their violation. This right is considered as the heart and the soul of the Constitution by Dr. Ambedkar. Also, the Supreme Court and the High Courts can issue orders and give directives to the government for the enforcement of the rights. So let's discuss the special orders, also known as writs, that are issued by the courts. The first one is habeas corpus. A writ of habeas corpus means that the court orders that the arrested person should be presented before it. It can also order to set free an arrested person if the manner or grounds of arrest are not lawful or satisfactory. Mandamus. This writ is issued when the court finds that a particular office holder is not doing legal duty and thereby is infringing on the right of an individual. Prohibition. This writ is issued by a higher court when a lower court has considered a case going beyond its jurisdiction. Quo warranto. This means that a person is holding office but is not entitled to hold that office. This writ restricts that person from acting as an office holder. Then comes certiorari. Under this writ, the court orders a lower court or another authority to transfer a matter pending before it to the higher authority or court. Now, apart from judiciary, many other mechanisms have been created in the later years for the protection of rights, like National Commission on Minorities, National Commission on Women, National Commission on Scheduled Castes. These institutions protect the rights of women, minorities and Dalits. Also, the National Human Rights Commission has been established by the law to protect the fundamental and other kinds of rights. National Human Rights Commission was established in 1993 by the government. It is composed of a former Chief Justice of Supreme Court of India, a former Judge of the Supreme Court, a former Chief Justice of High Court, and 2 other members who have knowledge and practical experience in matters relating to human rights. The Commission's functions include inquiry at its own initiative or on a petition presented to it by a victim into complaint of violation of human rights. This includes a visit to jails to study the condition of the inmates, undertaking and promoting research in the field of human rights, etc. The most significant intervention has been on disappeared youth in Punjab and the investigation and trial of Gujarat riot cases where its intervention proved effective. The Commission does not have the power to prosecution. It can merely make recommendations to the government or recommend the courts to initiate proceedings based on the inquiry that it conducts. Then we have directive principles of state policy. Now, some guidelines in the Indian Constitution were incorporated, but they were not made legally enforceable. This means that if a government did not implement a particular guideline, we cannot go to the court asking the court to instruct the government to implement that policy. These guidelines are non-justiciable, that is, parts of the Constitution that cannot be enforced by the judiciary. A separate list of policy guidelines is included in the Constitution, and the list of these guidelines is called Directive Principles of State Policy. Now, what do directive principles contain? The chapter on directive principles lists mainly 3 things: the goals and objectives that we as a society should adopt, certain rights that individuals should enjoy apart from the fundamental rights, and certain policies that the government should adopt. Now, the governments from time to time tried to give effect to some directive principles of state policy. They passed several zamindari abolition bills, nationalized banks, enacted numerous factory laws, fixed minimum wages, cottage and small industries were promoted, and provisions for the reservation for the upliftment of the scheduled castes and scheduled tribes were made. Then comes relationship between fundamental rights and directive principles. Fundamental rights restrain the government from doing certain things, while directive principles exhort the government to do certain things. Fundamental rights mainly protect the rights of individuals, while directive principles ensure the well-being of the entire society. When government intends to implement directive principles of state policy, it can come in conflict with the fundamental rights of the citizens. This problem arose when the government sought to pass laws to abolish zamindari system. Then the court held the view that the fundamental rights are so important and sacred that they cannot be limited even for purposes of implementing directive principles. Then the government was saying that the parliament can amend any part of the constitution, and the court was saying that parliament cannot make an amendment that violated fundamental rights. Then this controversy was settled by an important decision of the Supreme Court in Keswanand Bharti case. And in this case, the court said that there are certain basic features of the constitution and these cannot be changed by the parliament. So guys, this was all for today's video. We have completed chapter 2 of political science. So guys, if you find the content in the video to be useful, so don't forget to hit like the video and subscribe to my channel. Bye guys.